Justice. Thank you.
Thank you very much, Mr. Nate. The registrar's clerk can call the matter.
I am the registrar clerk for this hearing. Justices of the Constitutional Court, all counsel are online. I call the matter of Natasha Liebenberg and the state for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
I'm C.F. van Heerden. I appear on behalf of the applicant.
Thank you, Mr. van Heerden.
Good morning, Chief Justice, Justices, members of the court. I'm Mr. Mpela from the Office of the Director of Public Prosecution in the Northern Cape, Kimberley. I appear on behalf of the respondent together with Mr. Mdlalose from the same office. With your leave, may I allow him to show himself before the Chief Justice and the Justices?
Thank you. Thank you very much. Thank you. Before I allow Mr. van Heerden to address us, I hope that the challenges you had earlier, Mr. Mpela, are gone now. Is that correct?
Thank you, Chief Justice. We hope so.
Yes.
And we thank you for your indulgence in that regard.
Yes, okay, all right. I just need to say again what I said when you could not hear me. Namely, I was asking whether you were familiar with the directions that were issued in April with regard to hearings starting this term, which include the provision that each party would be given 30 minutes time to address the court without interruption.
Thank you, Chief Justice. We are aware of the Chief Justice directives.
Okay. Okay, no, that's fine. What I did say, which Mr. van Heerden was able to hear, and you probably did not hear, was that the directions do allow the Chief Justice to reduce that time, and that this case, I think that it is one where it can be reduced. And I thought that 15 to 20 minutes, maybe I'll say 20 minutes, should be enough for an address without interruption. I then inquired if that was fine with you. Mr. van Heerden said it was fine with him. So, but you didn't hear me, so I just want you to indicate whether that's fine with you as well.
It is in order, Chief Justice.
Yes, okay. Mr. van Heerden went on to say from his side, he does waive the right not to be interrupted even during that 20 minutes because he would like to get to the issues as soon as possible. Of course, I think he appreciates even when you waive that right, when the 20 minutes comes to an end, you can't continue addressing the court except to answer questions. So if there are no questions, he will be able to address us, but because he has waived, then he can be asked questions. But obviously, after 20 minutes, if we do have questions, he will address those questions. From your side, what is your position, Mr. Mpela?
Chief Justice, I don't have, together with my colleague, I don't have any issues regarding if any of the justices would want to ask questions as I go along.
Yes.
I'm fine with that.
Yes, and you understand that at the end of the 20 minutes, you can only ask questions. You can't address any other issues that the justices have not asked.
That is in order with us.
Yes, okay, all right. And the reply is 10 minutes, of course, Mr. van Heerden. in terms of those directions.
Thank you, Chief Justice.
Okay, all right. We will now start, and Mr. Van Heerden, your 20 minutes begins now.
Thank you, Chief Justice. Chief Justice and Justices of the Court, first of all, I did indicate that I waive my right for the 20 minutes then uninterrupted. I tried my level best in the heads of argument to show to this court what I deem is the unfair trial that the applicant received. Now, we submit that the applicant received an unfair trial. First of all was the evidence that was led to prove, according to the respondent, the intention, to prove the intention on the fraud charges. And the respondent replied it was not solely to show the bad character of the applicant. We submit, therefore, that it is conceded that that evidence was also produced to show the bad character of the applicant. And we submit that this evidence was irrelevant and inadmissible to prove the evidence of the intention of the applicant. We also submit that the case of State versus Naidu that was in the respondent's heads of argument is not on issue on the facts of this matter. In that case, the charges were racketeering, and the court found that the racketeering charges include previous conduct to show racketeering as such. But in this case, it was done to show intention to commit a fraud charge. And we submit it is inadmissible evidence. We further submit that the norm prescribed by Section 35(3) is a fair trial, and there must be substance to that norm. In other words, the court must seriously demand vigilance and effort in practice to adhere to what was promised in the Constitution. And this is a grave responsibility. If I may go to the second point then.
Mr. Van Heerden, I'm thinking about the outer contours or reaches of the interest of justice factor. Assuming that, I know there is a debate around this, but that this referring to what I'm just about to say, assuming that the Section 220 admissions actually do admit all the elements of the offenses of which the applicant was convicted, would it be in the interest of justice for us to worry about all these interesting constitutional issues?
Justice Madlanga, my submission is we must worry about, because the fair trial is the cornerstone of the Constitution in criminal law. Now, if we negate the issues beforehand, how will we know what role did it play in making the admissions in terms of Section 220? Because
remember, I said, remember the prefatory point I made was that assuming that all the elements are actually admitted. I'm saying this because I know there's the issue about, but this was not intended for her own benefit. So I'm saying, assuming that there's no issue at all and that all the elements are definitely admitted, so that any evidence, even the evidence relating to the issues that you are raising, would actually not have been necessary. Must we engage in all of this? Is it in the interest of justice for us to do so?
My submission, it is in the interest of justice to do so, Justice, because clearly you cannot take part of a fair trial and then says we condone the rest of the trial, who is mainly unfair to an applicant, because justice must be seen to be done. Now, if we take in this instance the evidence about bad character, etc., the evidence that no legal representative was there in the admission of Exhibit C, this is a fair trial, and that unfairness we submit led to the making of the submissions, or admissions in terms of Section 2020.
If Justice Madlanga is done, let me follow up on that, Mr. Van Heerden, and maybe this might be another way of putting the same question. Namely, if the admissions in terms of section...
And it didn't work. I don't know what was up.
There is somebody who has just intruded, so I hope they don't continue intruding.
I've muted them, Chief Justice.
Yes, thank you. So I'm saying, Mr. Van Heerden, my question might be another way of putting the same question that Mr. Justice Madlanga was putting to you. If the admissions in terms of Section 220 were enough to justify a conviction, why should it matter that evidence that evidence was led which maybe should not have been led, which would not have changed anything? Because the court could well have said, look, in the light of these admissions, there is enough evidence to convict.
I understand, Chief Justice. Chief Justice, the role, as I understand it, of this court is to guide lower courts in criminal trials what to do and not what to do. So my submission is we cannot condone irregularities, unconstitutional behavior, and said, no, that is fine, that part of the trial was fine. Now we proceed because of the Section 220 admissions. Now we say now everything in the trial is fine. I think, I submit with respect, that the role in the admissibility of the evidence that we say is inadmissible played a role in the eventual making of the 220 admissions. Because now the attorney for the applicant was in the position, the court allowed the evidence of bad character, he allowed admissions that was made without the help of a legal representative. So what must we do now? And I submit that lead to the making of the 220 admissions. So my submission is you cannot distance the unconstitutional evidence from the 220 admissions.
Are you saying that is, at least in part, because you say the evidence you submit is unconstitutional, influenced the making of Section 220 admissions?
Yes, Chief Justice. It did.
Yes. Is there a room in considering this aspect of the case for what is called the no difference rule in administrative law? Namely, is there anything wrong if one says, look, the section 220 admissions alone were enough to justify a conviction or convictions? Now, that's just an assumption for now, okay? But if that is the case, is there anything wrong with one saying, therefore, that the other evidence, makes no difference, because even without it, she would have been properly convicted?
My submission is you cannot divorce the two parts of the trial. And I say that, Chief Justice, because even pre-trial conduct is taken into account when a court must decide on the eventual fairness of a trial. So my submission in short is you cannot look at one aspect alone in this matter, because of what my argument is that the one lead to the other. And just on the 220, it's not an unequivocal admission of guilt. So in the judgment, the court the trial court took into consideration the evidence that was admitted, which we say were wrongly admitted. It took into account, even on appeal, that evidence was taken into account. With the admissions, who was not the unequivocal admission of guilt.
Sorry, Mr. Van Heerden. CJ, can I?
You may go ahead, Justice Kolopen.
Thank you. Sorry, Mr. Van Heerden, just two questions. The one, you say it's important for this court to give guidance to other courts with regard to how it should deal with questions of fairness. Given the extensive and comprehensive nature of the Section 220 admission, and given the language used therein, what kind of guidance can this court then give to a lower court when that court is presented with a 220 admission in the form in which it appears in this matter? Are you saying that court must then go back and interrogate every process to determine whether the admission was properly made? So that's my first question. And my second question, just very briefly, it appears that you're suggesting that the 220 admission was really made, not under duress, but because of the surrounding circumstances that prevailed at the time. If that indeed is the case, are you suggesting that those circumstances also would have prompted the applicant to show remorse? Because remorse would not have been an element of the 220 admission. It wasn't even necessary, but yet she expresses remorse for her conduct. So those are my two questions.
Justice Kolopen, I understand the question. If we look at the admissions that was made, and you look at the charge sheet, then it's clear that the version of the applicant from the start was she did not benefit. Now, what you get into during the trial is two different sets of evidence, and the one does not correspond with the other one. To name just the following. She admits in the 220 admissions that she signed all the documents that she was charged for. But the evidence in front of court was, no, Mr. Nakanana said, I signed those documents. The evidence of the investigator was clearly that some of the executors of the estate signed those documents. Now, the trial court is facing with this problem. I hear the evidence. It's part of the evidence in front of the court. And now there's admissions contrary to the evidence. And my submission is in that regard, the court must have decided what weight can be attached to this admissions. So if that answers your question.
Well, in part, because she remained consistent that she never benefited.
That's correct.
She said that from the outset, and in her admission, she said that. So on that score, the prevailing circumstances would not have prompted her to change direction. She persisted in that stance. So that's why I have some difficulty with your submission, that this admission was somehow engineered, not engineered, but it came into existence because of those circumstances. But you've answered that. Well, let me put it this way: you've responded to the question. Thank you.
Thank you.
Can I follow up on that, please, Mr. Van Heerden? As I understand it, Ms. Liebenberg was convicted of fraud and theft, 86 counts of fraud and 10 counts of theft, and also the forgery in uttering charges, but those were set aside as duplication of convictions in the High Court. Now, for theft, as I understand it, the material elements is the unlawful and intentional misappropriation of the property of another. And for fraud, the state must prove unlawful, intentional making of a misrepresentation that prejudices the complainant. Have I summarized the elements correctly?
That's correct, Justice Mujib.
In which of those two offenses must the state also prove that the misappropriation didn't occur for the benefit of the accused?
Not one, Justice Mujib.
So as I read the Section 220 admissions, you talk about equivocation. The only equivocation I see in the Section 220 admissions is the question of whether she benefited or not. But that's not a material element of the offense.
That's correct, but she was found guilty on that, Justice.
No, I come back to what I've asked. I said, those are the material elements. You and I are agreed about that. We also agreed that who benefited from her misappropriation, be it theft or fraud, both of them, the state doesn't have to prove who benefited because it's not a material element of the offense, of either of those offenses. So if there was an equivocation, it doesn't bear on the material elements of either of those offenses. So what I'm saying to you is, it seems to me that based on the Section 220 admissions, that those constitute an unequivocal acknowledgement of the material elements of fraud and theft, and therefore a plea of guilty in effect. And that is what the attorney, Mr. Ishmael, conceded before the regional court. Was he wrong?
Yes, he did so, Justice Majid. But I want to refer the Honorable Court to page 542, the admissions exhibit C, exhibit Y, paragraph 9. She admits my actions were wrongful and unlawful, and I show remorse for it, as I had not followed the proper procedure.
What do you want us to make of that?
Yeah, I was going to ask, what is the point there, Mr. Van Heerden?
She admits that she did not follow the proper procedure. She does not admit that she had the intention to permanently deprive the owner of the funds of that money.
I don't understand that submission, because if you read the statement as a whole, she says she completed checks for payees. She admits that it was wrongful and unlawful. She did not follow the proper procedure, and she says she hasn't benefited. Surely that's a misappropriation, although she doesn't call it by that name. What must we make of all of this? Because you must read this admissions against the backdrop of what Mr. De Toy, the branch manager, and Ms. Russell has testified about how these things work, that when there's a deceased estate, we know there's an estate account open, estate late. I think one of the complainants here is Janse van Rensburg. And so in the context of all of that, surely you must read the Section 220 admissions against that backdrop. Not so?
That is so, and also to the rest of the evidence, Justice Majid. And my submission is that Mr. Du Toit testified that money must be paid into an account and cash is not allowed to be given to a beneficiary. But he also testified that she is allowed to give them money even before registration as an executor for their certain exceptions, and he named the exceptions. She continued on that vein because if you look where the money did, and the only evidence of Mr. Nakanana is that whenever I need money to pay for the children or the tombstones, I went to her and get the money. Does that imply that she had the intention to permanently deprive Absa Bank of that money? And if you look at the checks, the admission is, I completed the checks for necessary pays to benefit from those checks.
20 minutes, Mr. Van Heerden, but you can continue answering questions.
Thank you, Chief Justice.
Have you done, Mr. Van Heerden?
Yes.
So really, your answer is the fact that she didn't benefit deals with the question of whether she had the necessary intent.
That's correct, Justice Mujib.
Yeah, I'll leave it there for now. Thanks.
Thank you, but Mr. Van Heerden, why would she have signed, was it the checks or the forms in such a way as to conceal the fact that she was the one signing, but creating the impression that it was the beneficiaries? There could not have been an innocent intent on that, could there be?
Chief Justice, she did that to bypass the system, if I'm allowed to say that. If you read the admissions in Exhibit C, she explained that they came to her every time they were in trouble, and she wanted to try and help them by bypassing the system and doing that.
Thank you.
She had the intention, sorry, Chief Justice, so she had the intention to bypass the process that she knew she had to follow.
That is so, Justice Potter. I'm not arguing that she's not guilty of anything, but I'm arguing that she did not receive a fair trial in the first instance, and she's not guilty on the judgment of the trial court that she received all the money.
Yes, I don't see any further indications from the
Chief Justice,
Sorry.
if I may.
Yes, Justice Daron.
Thank you, Chief Justice. Mr. Van Heerden, you may have covered this. What is the constitutional issue that the applicant says is before this court to consider? And I want to deal specifically with jurisdiction.
The constitutional issue is the fair trial that she's entitled to in terms of Section 35(3), Chief Justice. Justice Strong.
What? Yes, please continue.
Sorry, let me just, I hope the court can see me again.
Yeah, we can see you. We can see you, Mr. Van Heerden.
Thank you, Chief Justice. The concept of fairness of a trial, we submit, is the cornerstone of the Constitution in criminal law. And we submit she did not receive a fair trial, and that we must all try and rectify that by giving guidance to lower courts, or this court should rectify it by giving guidance to lower courts. That's the constitutional issue.
Mr. Van Heerden, In what way did the applicant not receive a fair trial?
By the trial court admitting evidence that was not supposed to be admitted, evidence of bad character.
Are you referring to Exhibit C, Mr. Van Heerden?
Now, I'm first referring to the past misconduct of the applicant that the respondent adduced for purposes of showing intention to commit another crime that she was not, or showing evidence about past misconduct that she was not charged for in this case, to show intention in this matter in hand. Secondly, that evidence was used by the state that was unconstitutionally obtained by a third party, namely the ABSA bank investigator, and then use it in a criminal trial. And my submission is that was unconstitutional obtained evidence that was used in a criminal trial.
Yes, so there's two grounds as I understand it, the evidence of the bad character and evidence that was unconstitutionally obtained. Now, can you refer us, Mr. Van Heerden, to the judgment of the magistrate where he relied on the evidence of the bad character to support the conviction?
Yes, it was also during sentence, Justice Tron, where
I'm particularly interested in the judgment on conviction, Mr. Van Heerden, to show that evidence was used to support the conviction.
If the court will allow me, let me just get the judgment. Justice Tron, it was only during the sentence procedure that he referred to that.
So we can agree then that the evidence of bad character was not relevant to the conviction.
We would not know, Justice Tron. We would not know what role that it played in the mind of the trial court in the conviction, because as I said,
Mr. Van Heerden, I'm sorry to interrupt you. I'm just conscious of time. We have the magistrate's court's judgment on conviction in front of us. In finding the applicant guilty, it's not reflected in the judgment that the magistrate relied on the bad character evidence.
That is correct, Justice Tron.
So would you agree then that the applicant cannot use that ground as a ground for that her fair trial rights in terms of the conviction was violated? If we use it in respect of sentence, that might be a different argument, but you agree with me that in respect of the conviction, the applicant cannot advance the argument that her fair trial rights were violated because the conviction was in part based on evidence of bad character.
My submission in that regard, Justice Tron, is that the evidence was before the court, and I cannot say what role did it play in the conviction of of the applicant, because, and
Let-
I say
let
that
me-
because
let me try to clarify my question, Mr. Van Heerden, and I do apologize for interrupting you, but I may not have put it as clearly as I thought. I'm saying, or I'm suggesting, Mr. Van Heerden, that based on the judgment of the magistrate's court, the judgment that we have before us, it does not appear from that judgment that the magistrate based the conviction or any part thereof on the bad character evidence. It does not appear from the judgment.
that is correct, Justice Strong.
So in order to rely on the fact or the allegation that the applicant did not receive a fair trial because bad character evidence was supposedly used by the magistrate, we would have to go beyond the judgment. That's what the applicant's asking us to do, is it?
That's correct. That's correct, Justice Strong.
Has the applicant made out such a case that we must go beyond the judgment of the magistrate's court? If you just give me a moment, Chief Justice, I'm hearing some interruption.
Yeah. Okay.
Yeah, I think I may have attended to it. Mr. Van Heerden, thank you, Chief Justice. Mr. Van Heerden, has the applicant made out a case that this court must go beyond the judgment of the magistrate to find that the magistrate, in convicting the applicant, relied on bad character evidence? Has that case been made out before the Constitutional Court or any other court?
We submit it does, Justice Strong. If we look at what the magistrate said after the 220 admissions were made, and the comment that they had, that suddenly everything now is admitted, it seems that he take into account, and that's my submission, he take into account the evidence of bad character, and that's why he said, you wasted the court's time. And we asked the court to find that that shows that he did indeed take into account the evidence of bad character.
Isn't that a bit far-fetched, Mr. Van Heerden? The 220, in the 220, section 220 statement, the applicant admits all the elements of the offense. And that's what the magistrate says. He says, now we have before us an admission of guilt. And up to now, there's been a dispute, but we have that now before us. Isn't it far-fetched to suggest that he made that statement based on bad character evidence? Because wasn't it true that as a matter of fact, the applicant had initially disputed, and then she changed her plea, and she admitted all the allegations, and wasn't the magistrate stating the factual position of what had occurred?
Justice Strong, yes, I agree with that. But the way he did that, before judgment, to say that you wasted the court's time, I submit, shows that he feels because of the evidence that was led, you've done that in the past, you were supposed to admit it from the beginning. And I feel that there we can see what role that you cannot take it further.
And I understand your submission, Mr. Van Heerden. Let's go to the second ground that you were rely or the applicant relies upon, Mr. Van Heerden, and that is that evidence was used that was unconstitutionally obtained. What evidence in particular are you referring to, Mr. Van Heerden?
The admissions contained in Exhibit C, Justice Strong.
Now, once again, if we refer to the judgment of the magistrate, is there any reference in the judgment of the magistrate to the admissions made in Exhibit C?
No, Justice Strong.
Then how can we say that that evidence was used to convict the applicant? When in the judgment of the magistrate's judgment based on conviction, he does not refer to any of the evidence in Exhibit C. how do we then draw the conclusion that the evidence in Exhibit C was used and the conviction was based on that?
Mr. Van Heerden, can you hear me?
I can hear you, Chief Justice, but I cannot hear Justice Tron.
Oh, okay. She's going to try again.
Yes, thank you, Chief Justice. Mr. Van Heerden, there is nothing.
Can you hear her now? Can you hear her now?
I can hear, but I don't see Justice Tron.
Oh, but you can hear her. If you can hear her, that will be done.
I can hear.
Okay,
Yes,
all right.
You might hear me better if I switch my video off, Mr. Van Heerden.
No, I can see you now as about okay.
Now you see me, now you don't. Mr. Van Heerden, if there is nothing in the judgment of the magistrate to indicate that he relied on the evidence in Exhibit C, can the applicant still advance that argument before us, that the magistrate in convicting her relied on evidence that was unconstitutionally obtained? Chief Justice, I'm not sure if I'm audible or if it's Mr. Van Heerden who may have lost connection. He seems to be frozen on the screen.
Seems to be frozen, yes.
Chief Justice, you are muted.
I'm sorry. I'm sorry. Thank you, Justice Matlanga. We could hear you, Justice Ron. Yes, Mr. Van Heerden appears muted. Are you back?
I can hear you, Chief Justice.
Oh, okay. Did you hear Justice Theron's last question?
Yes, Chief Justice.
Okay. Do you want to deal with it?
Yes, thank you, Chief Justice. My submission in that regard is, when a trial court gives judgment, he cannot simply ignore certain evidence that is in front of him. He must deal with it. In other words, he must say, I did not take into account the evidence of bad character. I did not take into account the admissions contained in Exhibit C. He must deal with it. If he does not deal with it, it does not mean he did not take it into account in coming to the judgment. So my submission is evidence in front of the court, which can be ignored and should have played a role in the judgment of the court.
Justice Theron, can you hear Mr. Van Heerden?
Not very well, Chief Justice, but I got the gist of his answer. I think it's an important aspect, but I understood most of what he's saying, but he is not clear at all.
I think he is saying, and I had him in the same way that you did, but I think he is saying, if evidence is before the court must state whether it took it into account or not. If it doesn't say that it did not take into account, and he will tell me if I'm misrepresenting him, then it must be taken that the court took it into account. I hope you can hear me, Mr. Van Heerden, and can tell me if I'm misrepresenting you.
I see you now, Chief Justice.
Did I misrepresent you in how I've put what you said just now?
Chief Justice, I didn't hear you at all. I could also not see you.
Oh, okay. I said the point you were making in response to Justice Theron was that the court must state whether it took the evidence into account or not if the evidence is before it. I deduce from what you are saying that you are suggesting that the mere fact that the court has not stated in its judgment that it took into account certain evidence that was before it doesn't necessarily mean that it did not take into account. It should state whether it has taken into account. And if it does state that it did not take it into account, we can't then say it did not take into account. Did I understand you correctly?
That's correct, Chief Justice, because the judgment must be based on the conspectus of all the evidence.
Okay, Justice Theron, did you hear my summary?
Yes, I did. Thank you very much, Chief Justice. But then that leads me to the same concern I had in respect of the first ground, Mr. Van Heerden. That is not the case that the applicant has presented to this court. The applicant has not presented the case to this court that the judgment is there, and we are not sure that the magistrate took into account unconstitutionally obtained evidence because he did not say so in his judgment. That's not the case brought. The case brought by the applicant is that unconstitutional evidence was taken into account as a matter of fact by the magistrate. Now, what I hear you to be saying is we don't know if the magistrate took into account unconstitutional evidence, unconstitutionally obtained evidence.
Justice Theron, I understand your question. My submission is, if a court gives judgment, it must account for all the evidence that is in front of him. And if he does not say specifically, I did not take this evidence into account because it's inadmissible evidence, because that evidence was presented before him and he accepted the evidence. I did not take into account that it was inadmissible evidence, then we must assume, because the trial court gives judgment on all the evidence, that he took it into account.
Chief Justice, thank you very much. Thank you, Mr. Van Heerden. I have no further questions.
Thank you, Justice.
Just one question flowing from that, Mr. Van Heerden. Do you agree that the purpose of writing a judgment for any judicial officer is to explain how he or she arrived at the decision that she arrived at?
I agree, Chief Justice.
Do you then not agree that if the magistrate has written a judgment or has articulated what he or she took into account, anything that is not included there, it is fair to take it that it's not one of the things she or he took into account? Do you not accept that?
With respect, I do not accept that, Chief Justice.
You don't go that far?
No, Chief Justice.
Okay, all right, thank you. I don't see any further indications from colleagues.
Chief Justice,
yes.
Just one question to Mr. Van.
Yes, Justice Mahoka, yes.
Yes, Mr. Van Heerden, I just want to take you back to the question posed to you by Justice Colapen about Section 220 admissions. I mean, ordinarily, this is information volunteered by an accused in a criminal trial. In this particular case, it is my understanding that you link the pre-trial process is what you call unfair evidence to Section 220 admissions. And you say this court should give guidance under those circumstances as to what should happen. What do you say? What do you suggest the magistrate should have done, given what was already known, what was already before the magistrate? Exhibit C, what you call the unlawful evidence, unconstitutional evidence, what should the magistrate have done with regard to the 220 admissions?
Justice Makgoka, under the following circumstances, the trial court should have decided what is the weight I can give to the admissions, considering the following. One, the applicant was crying during the trial. Secondly, there was problems with the legal representative. Thirdly, the evidence that she admitted to in the section 220 admissions are contrary to the evidence that was already laid in front of the court. And fourthly, she stated, I want to end this. This trial is hanging on my head for 9 years now. All that factors should have been a red light for the trial court. And under those circumstances, he should have decided what is the weight I can attach to these admissions. I hope that answers your question, Justice Makgoka.
You have responded to the question. Yes, thank you.
Thank you.
Thanks, Chief Justice.
Please, Chief
Thank
Justice,
you.
if I can.
Yes, Justice Procedural, go ahead.
Sorry, just on a follow-up of Justice Makgoka, are you saying that the court should have rejected the guilty plea? Is that your argument?
Not at all, Justice Procedural, but the court should not have said, now everything is admitted. The court should have inquired, why do you admit now that you signed all the documents, while it is clear that you did not?
Sorry for interrupting, but you were referring to crying and the illness of the legal representative, etc. That's why I'm asking this question.
Yes, but all these factors should have been considered to see if these Section 220 admissions were indeed made for the purpose of pleading guilty, because the admissions were contrary to what was made with the evidence that was already laid in front of court.
Yeah,
Okay, I'll leave it at that.
Just a
Sorry,
follow-up
yes.
on that. Yeah, Chief Justice, just a follow-up on
I'm
that.
sorry, is Justice Procedural finished?
I still want to ask just two questions.
Oh,
Pertaining to
let
the
her
bias,
finish.
okay, pertaining to the bias of the regional magistrate asking questions in address or sort of concurring with the prosecutor, are you persisting with that?
Yes, Justice Procedural.
And then lastly, the bad character evidence that you're referring to is, am I correct that that is the fact that she had previously had not adhered to the processes? Am I correct?
Yes, that she was charged with misconduct in the disciplinary hearing, found guilty, and received the final written warning.
Would you agree with me that there's case law that says, for instance, if one has to prove fraud, and you go and you open a credit account with the intention never to pay that account, that previous conduct where you did that previously could be used to prove mens rea, as the respondent is arguing? Would you agree with that?
I agree with that, Justice Procedural, but then a basis must be laid for that. It must not just be presented without any basis being laid for that.
And how would this basis have been laid?
The prosecution was supposed to inform the court that we are going to lead evidence about previous misconduct. And if the defense had any objection, and then the court was supposed to deal with the prejudice for the accused in that and make a finding that under these circumstances, this evidence can be allowed.
Thank you.
Justice Makgoka, I think you wanted to do a follow-up.
Yes, Chief Justice, thank you. Mr. Van Heerden, I just want to understand practically how you suggest the trial court should have dealt with the section 220 admissions. Are you suggesting that the trial court should have gone beyond what was contained in the admissions in sort of a trial within a trial to determine the circumstances that led to the making of the admission?
Not that far, Justice Mahoka. All I can argue is that the weight of these admissions should have been weighed up with the evidence already led, and that is as far as what I feel that the trial court should have taken it.
Okay, thank you. Thanks, Chief Justice.
Thank you. I don't think there are any further indications from colleagues. Thank you very much, Mr. Van Heerden. I will now give the opportunity to Mr. Mpela. And again, Mr. Mpela also said he doesn't mind being asked questions, but he has got 20 minutes. During the 20 minutes, he can be asked questions. When the 20 minutes expires, he can only answer questions after that. Mr. Mpela, your 20 minutes starts now.
Thank you, the Honorable Chief Justices. My point of departure is the following. There is no constitutional matter or an arguable point of law of general public importance which ought to be considered by the Honorable Justices. As required in terms of Section 167, subsection 3, subparagraph B of the Constitution 7th Amendment of 2012. I must apologize. I did not include this in my head because I reserve it as an opening statement. That is the threshold that the applicant must first pass in order for the Honorable Court and Justices to adjudicate on this matter. Matters that tend purely on a question of fact are not constitutional matters. Similarly, matters involving the straightforward application of the law that do not raise constitutional question about the validity or the proper interpretation or development of the law are not constitutional matter. And in this regard, I refer the Honorable Justices, Chief Justice, to Ian Carey and Johan de Waal, the Bill of Rights, Handbook 6th edition at page 99. We respectfully submit that it is not in the interest of justice to grant leave to appeal to the applicant. Secondly, our approach with regard to the application for leave to appeal on the merits is that there must be a reasonable prospect of success. We respectfully submit, Chief Justice and Justices, that there are no prospects of success based on the merits. We will then proceed to deal with our submission as from page 19 of our heads. But in the interest of time, I want to sum it up. What is before you, what is complained before you is bad character, is the admissibility of section 220, is Exhibit C, to put it in a nutshell, unconstitutionally obtained evidence. That is been argued before you. Now, and section 220. Counsel or Mr. Van Heerden, my learned friend, has given reasons why he believes the 220 admissions should not have been taken into account by the court. On the issue of bad character that has been raised, suppose applicant pass the first door, which is the threshold, which then gives this court jurisdiction to adjudicate on this application. That is if applicant passed the second door, which is now, are there merits that are to be adjudicated by the honorable justices? Are there prospects of success, reasonable prospects of success in this regard? Now, we are saying, and this is our submission, our intention when we led the evidence with regard to disciplinary processes, warning statements that were given to the applicant, was basically to show the court the intention, the requisite intention that the applicant proceeded in committing the charges that she was convicted of. Secondly, as the state, the law requires us, as the respondent in front of you, the law requires us to lead evidence that is relevant to the facts in issue. One cannot ignore evidence that is relevant to the facts in issue, and that is the hurdle that we had. The other aspect is, how does one go and prove intention? We had to show the court that despite the fact that the applicant has been warned to an extent of even being on the brink of losing her job, 2 warnings, she continued handling the deceased estate. We had to show the court. We had.
Mr. Mpela,
Chief Justice?
It looks like your problems are coming back. Maybe if you continue, you'll be able to. I thought I could not hear you for some time. Try again.
My apology, Chief Justice. I have to apologize. We have an issue of technology, but let me reiterate for your benefit, Chief Justice. The point we're coming at, our line of thought, our reasoning is that as the respondent, as the state, we have an issue of leading evidence before the trial court, which is relevant. Now, the issue with regard to disciplinary processes, warning statement of the applicant, it was incumbent on us as the state to lead that evidence because that evidence was relevant to the facts in issue before the court. If I may put it simply, in the disciplinary processes, the issue there was the applicant dealt with deceased estate in a manner that was uncalled for. The charges that we pursued against the applicant dealt with or deals with the same issues. Applicant in the charges that we preferred against her in a protocol dealt with deceased estate in a manner that was uncalled for. She was warned, don't do it, and she persisted to do that. So we had that issue of relevancy to place it before the court. Secondly, it was the issue of the state proving the intention that when the fraud charges were committed by the applicant, she did so with the requisite intention. And in order to demonstrate to Chief Justice and justices, if I may refer you to page 21 of my arguments or submissions, going to page 22, and where the following is said. In the 220 admissions, that is now Exhibit Y, applicant says the following. At 6.4 of my submissions, Applicant is saying she did not follow proper procedure when she completed the checks for the necessary payees to benefit from the checks. Now, if you read that in conjunction with Exhibit A, we wanted to prove, we wanted to avert this kind of a situation, to say, I did not know. Oh, I can't. There's a problem here.
We can hear you, Mr. Mpela.
Thank you, Chief Justice. There seems to be the technology that is catching up again. I'm not visible, but if I'm audible, then
right.
may I proceed with your...
You may proceed.
I thank you, Chief Justice and Justices. Now, that is basically what we wanted to deal with from the onset. And with the state, unfortunately, we have to put the evidence at the relevant time when we have that opportunity to do so. We cannot wait at the last end. And exactly what we envisage it might happen in the trial, that is exactly what the applicant is saying in the 220 admissions. I did not know the procedure, but yet, in terms of disciplinary processes, she has been warned to an extent of losing her job. So we had the issue of intention to prove, we had the issue of relevancy, that the facts of disciplinary hearings were the same as the facts in front of court. Now, with regard to Exhibit C, the court went to an extent of establishing a trial within a trial. Exhibit C was not accepted by the court willy-nilly without following proper procedure, trial procedure, which, if one looks at it, it's a fairness of the trial that the presiding officer in a court was alive at all relevant times. Let's take it fair and say, we might have had, as the state, to introduce bad character evidence as applicant allege or submit with due respect. We might add in dealing with section or Exhibit C. What seals the applicant case is the section 220 admissions. What was the case that the trial court delivered the judgment on? The trial court is sitting with an accused who is saying, I have forged the signatures of the beneficiaries. I admit all the elements of the offenses. I have withdrawn the money, but I did not benefit out of this money. I gave it to the beneficiaries. I was just a good Samaritan. Now, Mr. Van Heerden wants that evidence. And his interpretation of that evidence is that the court should not have considered that. The court should have chucked that evidence out because applicant was emotional and all that. But that is not correct, because as at the time when this section 220 admissions were tendered before the court, applicant was not crying, and applicant did not raise any fact that she was unfairly treated or that those section 220 admissions were solicited by the attorney or were made without her consent in a sense of sober senses and all voluntarily and all other elements. There is no indication before the trial court. The trial court is sitting with a document that says, I admit all the elements of the offense, except the fact that I did not benefit. Now, very importantly, the elements of the fraud has been clearly said or put by the Honorable Justice Majid to my learned friend, and he could not answer because it is not one of the elements of fraud that there must be a benefit. It is not. And my learned friend can come up with any authority that is in contrast with what I'm submitting before. There isn't an authority that I know of that says the elements of fraud, amongst others, there must be beneficiation of some sort. In other words, the applicant must have benefited in order for fraud to stand. There isn't. And if he has, I would love him to supply us with that. The theft, if we look at the theft, if you take, that is now what the applicant want the Honorable Justice, Chief Justice and Justice to believe. If you take money from Van Rensbeck's account and you give it to another beneficiary who's not connected by any means whatsoever to Mr. Van Rensbeck, you are stealing. It's theft. Whether, I think where there is misconception from the side of the applicant, advising my learned friend, is that the state could not prove that directly. In other words, the state does not have, or the respondent does not have direct evidence to prove that applicant misappropriated the funds. And the trial court had to concede. That is the misconception, because circumstantial evidence, it is evidence before court. And if one read the facts as adjudicated by the trial court, if I want to benefit my learned friend, why is there a need for me to forge his signature? Practically does not make sense. And those are the issues that the trial court was faced with. In the light, of course, of what the Section 220 submissions by admissions that were made by the applicant. Now, the gist of the matter, the gist of this application, as I said in my opening statement, is, and I want to put it clear for my learned friend as well, is there, has my learned friend passed that threshold of jurisdiction that was clearly asked by Justice Theron, if I'm correct, earlier on? Has my learned friend make up a case with regard to the appeal on the merits? And this has to be read in conjunction with Section 220 admissions, Exhibit Y. That Exhibit Y stands. It puts everything beyond question. And that is our take. And I have referred Chief Justice and justices to the cases that are dealing with unconstitutionally obtained evidence. The fact that my learned friend says Exhibit C was unconstitutionally obtained, it does not necessarily mean that is the end of it. Because, and I would like to borrow from if I refer the Chief Justice and Justices to page 26 of my head or my submissions, where in Key versus Attorney General, with reference to Ferreira versus Lavin, where it was said, fairness is an issue which has to be decided upon the facts of each case. And the trial judge is the person best placed to take that decision. Fairness may at times require that evidence unconstitutionally obtained be excluded, but at times, fairness may—
2 minutes left out of your 20 minutes. There is 2 minutes left out of your 20 minutes. Mr. Mpela, you may proceed.
Thank you, Chief Justice. I just want to wrap that quote, if I may, in the 2 minutes. And yes, I was at but at times fairness may require that evidence, albeit obtained unconstitutionally, nevertheless be admitted, close quote. Now, correctly so, the judgment of the court deals with the Section 220 admissions. The trial court had no other way but to consider the 220 admissions. As I have indicated in my arguments before the trial court and the appeal court, the Northern Cape High Court, Kimberley, the point that the court could not do away with is, here's the applicant, here's the accused who's saying, I've committed all this, admitting all the elements of the offense. The court was supposed to deal with that aspect. There's no other way the court could have ignored that. Chief Justice and Justices, that is my submission. My submission finally is that applicant has not passed the threshold of jurisdiction. Secondly, on the issues of merits, the Section 220 admissions that were made seals it. And therefore, this application must be dismissed by the Honorable Chief Justice and Justices. That's my submission. I thank you.
Thank you very much, Mr. Mpela. I don't see any indications from the justices of anybody who wishes to ask questions. In the light of that, I will give Mr. Van Heerden the opportunity to reply. Mr. Van Heerden, you have 10 minutes to reply.
Can you hear me, Chief Justice?
Yes, I can hear you loud and clear, Mr. Van Heerden.
Thank you, Chief Justice. Thank you, Chief Justice and Justices, for the opportunity to respond. Chief Justice, just about jurisdiction, I want to add the following is important. If respondent concede, they might have erred in doing this and they might have erred in doing that, there is also another factor that must be taken into consideration. And I refer to that on page 9, paragraph 26 of my heads. And that's a principle of justice must be seen to be done. In S versus Ramatar, the court found that any right-minded and reasonable observer who might have been in court at the time could not have helped but have great doubts as to whether or not the magistrate could give the accused a fair deal, given that she had elicited the criminal record even before she took the plea. In other words, it's not only the rights of the applicant that must be taken into consideration, it is what transpired in court and what will the learned or the informed observer think about that. I will also refer the Honorable Court to paragraph, let me just get it, 63 of my heads, where in the case of S versus Lagranci, the court found that fairness and impartiality must both subjectively demonstrated to the informed and reasonable observer. And my submission is that is where jurisdiction is obtained in this matter. because it's a fair trial right of the applicant. Inadmissible evidence were adduced and accepted, and my submission is for this court to give content to the notion of basic fairness in this regard. Thank you, Chief Justice.
Thank you very much, Mr. Van Heerden. There are no indications of questions from the justices. Thank you very much, Mr. Van Heerden. Thank you very much, Mr. Mpela, for all your submissions. The court will take time to consider the matter. And once the judgment is ready, the parties will be informed. In the meantime, judgment is reserved and the court adjourns.
Thank you, Chief Justice.
As a justice.
Today's proceedings are concluded. The host will